SJC-12344, Commonwealth v. Rogelio R. Buckley.
Mr. Malin, good morning.
Good morning. May it please the court, Matthew Malm for the appellant Rogelio Buckley. In Santana, this court gave its blessing to pretextual traffic stops. In the 20-plus intervening years, Santana spawned what has become a common police practice of using civil traffic infractions to stop people for illegitimate reasons.
Counsel, can we slow down for a minute? Didn't the concept exist before Santana? Pretextual, what are alleged to be pretextual stops?
Yes, Your Honor, but
So where, do you know where it originates?
the pretextual stop?
The idea that was sanctioned in Santana?
I'm not aware of its origin, Your Honor. But what it did was it gave its blessing to that, and it has been used repeatedly to justify stops on illegitimate reasons, for illegitimate reasons. Even one pretextual traffic stop is one too many because they serve no legitimate governmental purpose.
Is the investigation of a narcotics offense an illegitimate reason?
It is not, but to stop somebody as part of that investigation when you don't have something amounting to reasonable suspicion, that would be a violation.
No, I'm not sure if you finished, if Justice Gaziano is finished, but in this case, it doesn't appear to be argued, but wouldn't you say there was reasonable suspicion to stop on suspicion of a drug transaction, given everything the officers knew and the surveillance that had been undertaken and what they saw happening?
That argument was waived by the trial ADA. He conceded that there was no reasonable suspicion.
Well, below the argument that was raised before the motion judge was that this wasn't, the race issue wasn't raised in front of the motion judge, correct?
Yes, Your Honor.
So we don't have a record on what the judge believed or didn't believe regarding the purpose of the stop.
And the argument, I'm not arguing that this was a race-based stop. You know, we're not arguing Laura, that this is an equal protection claim. We're just arguing under Article 14 that it was a pretextual stop for illegitimate reasons.
So you want us to, so if a police, I'm just trying to get the scope because your brief spends a lot of time on that issue.
Yes.
I'm trying to figure out where we are because you have a stop, arguably, where under the authority rule for a traffic violation, and your argument is, I guess, that it wasn't really for a traffic violation; it was to stop these people for the drug offense.
Yes, Your Honor. And they didn't have reasonable suspicion of that.
Of the drug offense.
Yes, and so that's the argument, and the race element comes into it as a larger policy argument because a lot of these pretextual stops involve explicit and implicit race-based reasoning, and so by allowing courts to consider.
Isn't this the wrong case for that?
Isn't the driver's white, right?
Yes, Your
and
Honor.
the passenger's black. So
Yes, Your Honor. The
so
defendant.
you don't have a race case in any conventional sense, do you?
No, I'm not. Again, I'm not arguing this was a race-based stop.
Shouldn't we? I'm sorry.
Go.
Shouldn't we wait for the driving while black case to decide a driving while black case?
No, because there's still the core constitutional issue that civil traffic stops are so easy to come by that it provides no protection against arbitrary police action, and that affects everybody and for any illegitimate reason. And race is important to consider in this case because a large portion of these pretextual stops, race plays a part. You can see it in the statistics where minorities are stopped at twice the rate, give or take, of non-minorities. And by allowing courts to inquire about pretextual stops, just that they're illegitimate for whatever reason, why they're illegitimate, that can take a significant chunk out of these race-based stops.
Shouldn't we decide that on a better record than we have here? where that's argued in front of the lower court judge, and we have his or her findings regarding that issue?
Well, I think this court is perfectly capable of recognizing the statistics and the issue that race plays in pretextual stops. It's been identified by this court numerous times in other decisions.
Now, is there a claim here that the stop was prolonged to conduct investigation regarding the drug case? I couldn't tell.
Below it was argued that the scope of the stop was exceeded, and I argue in the brief that the scope was exceeded when the plainclothes detectives took over the stop. They interrupted what was a routine traffic stop, surrounded the vehicle, identified themselves as detectives, and asked about the presence of narcotics. At that point, the stop switched from being a routine traffic stop and became an investigative stop without any justification.
Okay, so I've read the opinion below, but have not gone back to the record. Officer Nelson is the officer who makes the stop,
Yes.
and then Detective Bombardier shows up. Do we know how long after the stop it was before Detective Bombardier showed up at the driver's side door?
I think there might have been some testimony about the amount of time, but it was short enough to the point where he interrupted Officer Nelson while he was still getting her information. He was able to get her registration and her name.
Okay, so it's still, but Officer Nelson is still in the process of obtaining registration at that time,
Yes, Your Honor.
which would be appropriate for a traffic stop.
No, so I think you're looking at the temporal scope, so you're focusing on the time limitation. I'm arguing that scope can also be viewed, and it's in the case law, it's in constitutional law, that the scope can also include the questioning, what questions were asked, the tenor of the stop. In Feyenoord, the use of drug dogs, that expanded that was viewed as expanding the stop, not just because it extended the time, but because it changed the dynamic of the stop.
So why don't we decide this case as we have in other civil motor vehicle infraction cases, under the purpose of the stop, the scope of the stop not exceeding the purpose for which the person was stopped?
I'm sorry, I don't understand the question.
The case law that you reference on the scope of a civil motor vehicle stop, if you say it was exceeded, why shouldn't we decide this case on those grounds?
Yes, my client could get relief on those grounds, but I think the court is also an important time for the court to consider whether pretextual stops should be allowed, whether the court should be complicit.
But doesn't that principle address your problem that, you know, the stop, this is just as Gaziano said, the scope of the stop needs to reflect the purpose of the stop. So we have addressed the principle you're talking about. And we've also have Santana that if you think an officer is doing these types of pretextual racial stops, there's a way of addressing that too.
You're referring to Laura?
Yeah.
Yes, so Laura has.
But I think the first point is, I think the one I'm more focused on, which is if the purpose of the scope of the stop embraces the purpose, you can't start straying too far from that, or the stop is going to be found impermissible, right?
Yes, but well, first of all, I think the act of being stopped is problematic for an illegitimate reason.
But they're stopping, they have a legitimate reason to, you don't, if they were going to just give him the ticket for not driving with his lights off, you'd be fine with that, right?
No, the problem is this supposedly legitimate reason, the civil traffic infraction, provides no protection because it's so easy to come by. It provides no protection from arbitrary action.
But there is a protection, which is the scope of the search should reflect the purpose of the stop.
So I think, Your Honor, yes, a scope is intrusive into privacy and is bad, but the stop itself is also a privacy intrusion, and that should be protected against, and that's what Santana is not preventing.
Only if the search doesn't match the purpose, right? If they had just pulled him over to give him a ticket for driving with his lights off, driving giving her a ticket for driving with her lights off. You wouldn't have a problem with that, obviously, right?
So, no, I would have a problem with that because the real reason for this, so you're saying, well, let's look at the real reason for the stop. Are you saying the real reason for the stop was the lights, or are we acknowledging that's a pretextual stop? And like they did, like the prosecutor did below,
I think the law tends to not do what you're asking it to do, which it says, are you acting in an authorized way? And there was an objective reason for the stop. And then, I mean, I see your point of you're exceeding the scope of the stop,
yes.
but you're saying that we've got to decide subjective intent of every officer and, you know, get into their heads each time, and then determine whether the initial stop is proper or not.
Yes.
We've never done that before, have we? Neither the feds or the state have done that, right?
There are 2 states who have done it, Washington and New Mexico. And also, we do similar inquiries in other areas of Article 14 law, inventory searches and administrative searches. So the court's perfectly capable of doing this. Really, the only thing that,
I'm sorry, let me ask you a question, which is a common occurrence. Police are conducting a drug investigation. They want to identify people who go to a particular residence. A purported buyer or distributor takes off down the street. He's going 50 miles an hour in a 30-mile-an-hour zone. The police pull the person over. They get the license information. They want to find out who this person is to further the investigation. And they let the person go. Is that okay?
so that would be mixed motives. So of the police, they observe what, I think 20 miles per hour over, I think that could be considered a significant traffic violation.
All right, so that's, I guess my question was, is that okay?
And so this could be addressed in the analysis that the court adopts. And I think which the core question would be, would the stop have occurred without the improper motive? So you have the improper motive, and then we ask, would the stop have occurred without that? And and one of the factors the court could consider in making that.
I'm going to ask you to play judge. Is that okay?
Well, I think it should be a totality of the circumstances test, but I think that's a strong argument that it was okay, because I think most police officers observing that would stop them regardless of any other motive.
5 miles over the speed limit, is that okay?
That would have to be on a case-by-case basis. So I think that we're getting into what the trial court is perfectly capable of doing, is assessing these, and it happens in Fourth Amendment and Article 14 law all the time, on a case-by-case basis, determining that question.
So that's the guidance we give our judge. We adopt your standard, and we have the common law that says 5 miles over a speed limit, no. 10 miles over a speed limit, yes?
No, I don't think there would be a bright line. A bright line might emerge through the evolution of case law, but it should be a case-to-case, case-by-case basis, and there's going to be a lot of other factors other than just the speed limit that the court can consider.
And in the world you want us to enter, if there were a finding that the police officer's purpose for stopping was something other than a traffic violation, what would be the consequence?
Exclusion.
Exclusion of?
Evidence found as a result of the stop.
Okay, thank you. Unless you have anything else.
I think I've covered all I needed to cover. I'll just rest on the briefs for the rest of the arguments. Thank you.
All right, thank you. Ms. Lee, good morning.
Good morning. May it please the court, Mary Lee, Special Assistant District Attorney for the Plymouth District for the Commonwealth. This court asked a question when taking this case on direct appellate review after the briefing in the appeals court, and I think the question would ask me for the answer, why should Santana be affirmed or remain unmodified? And my first answer to that is the purpose of the exclusionary rule. The exclusionary rule is to deter police misconduct. It is not misconduct to enforce the traffic laws. And an officer's subjective motive to investigate crime is also not a bad thing. That's not misconduct. It's at worst neutral. And
But
so,
can I ask, is it okay to racially profile, though?
no, absolutely not. And this court has already said that in Betances And it's already provided a method for addressing that in Laura, which the defendant did not take the opportunity to use in this case. And so I would point to the language in Santana, which is at issue before this court, which is that the fact that the troopers may have believed that the defendants were engaging in illegal drug activity does not limit their power to make an unauthorized stop. And then I would point to a similar scenario, though not exact, it's not a traffic stop, in Commonwealth versus Gentile. It makes no sense to rule that the police may search the vehicle of a person who admits to the possession of marijuana or weapons, but not the vehicle of one who admits to such an offense but is also suspected of a more serious crime. At the time of Gentile, marijuana was prohibited. What those cases are saying is that at a common sense, practical level, it doesn't matter that the police suspect more, even though they may or may not have reasonable suspicion yet, when there's an objective violation of the traffic laws. But at best, the rule in Santana, which is also the federal rule, permits the police to watch for, be alert to, and to act on evidence of other crimes. And I would point to cases where the police, both in Massachusetts and outside of Massachusetts, have been able to not only capture felons, but have prevented likely crimes in the future. Timothy McVeigh and Ted Bundy were stopped for license plate violations. Joel Rifkin was stopped for a motor vehicle violation as well. I'm sorry, Ted Bundy, I think, was speeding.
But those weren't
was stolen.
pretextual, those were just pure traffic stops.
Those were situations where there were traffic stops, but the police during Timothy McVeigh's, after he had committed the Oklahoma bombing, people were looking for who was doing the Oklahoma bombing. The police needed to be alert to whoever appeared in front of them, and Timothy McVeigh had a license plate violation. Ted Bundy was actually in a stolen car, I misspoke, and Joel Rifkin had a license plate violation. But I would point to here in Massachusetts, Ryan Boyce, this court's decision in Ryan Boyce. He was speeding at 1 in the morning, and the police stopped him, and then he took off before the police effectuated the stop, and they kept on him and stopped him again, and they recovered the body of his 6-year-old cousin he had raped and murdered before her grandmother even knew she was missing.
Right,
So what-
I mean, I think you're missing his argument, which is not that during the course of a traffic stop, it may turn out that there's information leading to the discovery of a crime. I don't think that's what's before us. I think in this particular case, you have Detective Bombardier telling Officer Nelson, stop the car, before Officer Nelson has seen any violation of the traffic laws. So you have Officer Nelson now following him, waiting for him to commit some violation of the traffic laws. And I think it's fair to say that if any officer were to follow most of us for long enough, they would find some violation of a traffic law, failure to signal, going 40 in a 35-mile-an-hour zone. And so an officer has the ability to stop most anybody on the basis of what that officer would never have stopped him before. That's the issue before us.
No, I understand. I want to bring out the importance of not requiring the police to close their eyes to criminal investigations.
I think in fairness to him, that's a separate issue. I don't think anybody is saying if you driving 80 and you, on a 50-mile-an-hour zone, you stop the person and you discover a firearm in the car that you're supposed to close your eyes because this is a traffic stop. I think it's really the issue that I'm describing, which is the source of concern.
The amicus briefs are, for the defense bar, even going so far to say they don't want the police to be able to approach people and to speak to people, which is far afield of the question here. So I don't want this court to lose sight of the importance of traffic stops in criminal investigations, yes.
But I'm sort of focusing you on the pragmatic fact that
Yes.
we think we all know that where police want to stop somebody for an investigative reason, if they follow them long enough, they'll be able to find some justification to do so. And too often, historically, nationally, let's keep Massachusetts out of it, race has been a factor in terms of that stop. I mean, that's the core issue.
That's the core of his argument, but it's not supported by the evidence here. The police saw this person when they were leaving the suspected drug house. They pulled out into traffic, went into the other lane, when backing up, drove with their lights off, and that's when the decision was made. So there was already a traffic violation before the call was made. Keep an eye out for that car. And then the police officer followed that car for, I think, a quarter of a mile, and it was doing 42 in a 30-mile-an-hour zone. And then Detective Bombardier came, I believe it's within a minute. I'm sorry, I couldn't find the citation for that, but I believe Detective Bombardier came within a minute.
Did the motion judge find the traffic violations to be credible? That the police officer was not lying that there was a traffic violation?
He put both in his factual findings, but he focused on the speeding when he was saying that the stop was authorized. So he said speeding. He didn't say that 40 in a 30-mile-an-hour zone, 42 in a 30-mile-an-hour zone, but he mentioned the speeding. That was the basis for the stop in the judge's findings, although the lights off was mentioned, if my recollection's correct.
Understanding that right now, as the law is, it's the authorization test, whether the officer has the authorization to stop. What are the drawbacks to having a reasonable police officer test?
I would suggest we don't want the police to be second-guessing themselves or closing their eyes to it. And on the other side of it, we don't need that rule because this court has already set those protections in place through Betances and given the process for that through Laura. I would like to correct something that was in the amicus briefs saying that Laura has never been used to suppress evidence. According to Shepard's, Laura has been cited 17 times, and one of those cases cited in Shepard's was a Superior Court decision by now Appeals Court Justice Agnes, where he suppressed evidence based on Laura. So there's a Superior Court decision that's published in Lexis that does it. It's Commonwealth versus Vega Robles. In addition, this court has seen the proper use of Laura addressed not in racial discrimination cases, but in selective enforcements based on gender in Washington W., which ended up getting dismissed because the Commonwealth did not provide the discovery required under Laura. And Plymouth County's case, Commonwealth versus Bernardo B., which is a juvenile case, which was remanded for just that discovery process. So Laura is not an impossible standard at all. My suggestion to this court is it has not been used by the defense bar. The defendant did not use it here, and that's why you have no record. You don't have those raw statistics, which the amicus briefs show are available. Massachusetts has been collecting them. And you don't have those raw statistics. You don't have an expert analysis of those statistics. What you have before you are advocates in law review articles and journals who are doing important work trying to get correct social change, to bring us all together as people. But those advocates' articles can be manipulated, and you can see it in one of the briefs. I'm sorry, I don't have it in front of me. One of the briefs in a footnote talks about, it was surprising in the amicus brief to them that Hispanics were stopped actually at a lesser rate than expected. And then they said, when controlled for age. And then they went on to say, but Hispanics and Black people are searched more when they're stopped, when controlled for time, location, gender, age. What does that mean when you are modifying the statistics to make them comprehensible? I don't know what that means. Perhaps that's correct. The way we find out what that means is the defendant raises it under Laura, gets the discovery he needs, presents the statistics, and has an expert come in and analyze them, and then the Commonwealth has the opportunity to be heard, and the Commonwealth has the opportunity to argue, and the judge makes findings. The defense bar and the defendant here are asking you to be a fact-finding court, which is not your job, and it's not the way we do our common law, and it's not stare decisis. My biggest concern, if you are to take on the substantive considerations under Santana that the defendant is asking you to do, is what that is going to do to our procedural process. Commonwealth versus Mubdi, written by Chief Justice Gantz in 2010, is correct in its wisdom and its application of Rule 13. A defendant is required to raise all his grounds in a motion hearing. It doesn't just tell the judge whether an evidentiary hearing should be heard. It puts the Commonwealth on notice as to what to present to that hearing so that you have an adequate record. If you consider this issue on its substance, I'm very concerned that you are implicitly overruling Mubdi, and that is a horrible mistake for a criminal procedure. The defendant has a way to do this claim, but not in this case, because in this case, when you look at the evidence, the police did not even know the race of the people going in and out of that house.
What has to be distinguished here pernicious is an understatement as far as stalking somebody based on race or ethnicity, and it's a serious concern. All I have to do is look at the statistics to recognize that serious concern. But that has to be differentiated from the idea that Commonwealth versus Santana and pretext is a bad thing. And I think that's what you were getting at.
Yes.
That's what we want the police to do. We want the police to investigate, to create more opportunities that there might be a dead 6-year-old in the car. That's not bad. What's bad is racism. What's bad is the perniciousness of a stop that's not based on some reasonable, articulable reason. But pretext stops reduce crime. They save lives. And that's, I think, what you were getting at.
Yes, so I think pretext has, kind of a pejorative meaning to it. What we're really talking about here is a mixed motive. The officer has an investigatory purpose along with the proper traffic stop. And as long as he's not prolonging that stop under Torres or this court's recent decision in Cordero, which I apologize, I gave to the appeals court as a 16L, and I neglected to do so when we provided our materials. But this court's already said this is the limits of what a traffic stop is. This court has already said you are not permitted to stop people based on their color or their race or their gender or their ethnicity or their sexual preference. That's not okay. That's Betances. And if you think that's happening to you, you can use Laura. And I think it's really interesting that the Commonwealth has used Santana, of course, to its advantage. It's a very helpful tool, and that has been cited 179 times, and Laura has only been cited 17 times, according to Shepard's. Yeah, the best thing that could come out of this case is an invitation to properly use Laura and to get this information in front of this court.
If I can turn you to the Commonwealth versus Cordera case decided this year, written by Justice Gaziano, that essentially says you cannot prolong a traffic stop for the purpose of conducting an investigation unless there is some information developed during the course of the traffic stop that would justify that. Was that argument made here in this case, that the stop was prolonged for an investigative purpose that went beyond the traffic purpose?
To the extent that it was made in saying that the defense claim was really there was no traffic violation, the police just stopped and don't believe the police officers.
Put that aside for now.
So we'll put that aside because the judge disbelieved that. There's no evidence that it was prolonged here. Detective Bombardier came right up and began speaking to the driver before anything had occurred. The driver did not have her license in her possession, so that's a violation of Chapter 90, Section 11. You're supposed to have it immediately available. So the officer who conducted the stop went back and checked on the licenses, and by the time he got it, I think he said it took him 2 minutes, the defendant's driver had already given consent and the truck was being searched. That's my understanding of the facts of the case. So there's no elongation of it because she's an adult and gave proper authorization to search her truck.
But you would agree that it would be a different circumstance if the officer had stopped the vehicle and then waited 10, 15 minutes for the detective to show up to follow up with some questioning.
Or a dog sniff or whatever reason. I mean, we're not going to just stop people and have them sit there all night, and that is clearly prohibited already under Torres and Bombardier. This court has done an excellent job already of making sure people's rights are intact and that defendants who feel like their rights have been violated have a way to get at that. It simply hasn't been done here, and I would ask...
Problem. I mean, there's a reticence to bring up Laura. And something has to be done about that reticence so that if somebody's being stopped based on race and ethnicity, that gets litigated. And so there needs to be something said or something done so that that's an issue that can be addressed.
Yeah, I agree 100%, because that is one thing we don't want. We don't need more division between the police and the communities they serve, and racial discrimination in stops does that, and this court's doing its best to prevent it.
Okay, thank you.
Thank you.
And we'll take our morning break.